in case 18-6788-DC, Cody v. Hurley. Both parties are present via Zoom. We're dealing with Xander and Landon, 11-9, I believe they are. This is father's motion for custody. There's some history to this. There was a FOC order for parenting time. Dad has to get the psychological for that from Dr. K and this kind of stuff to be able to do parenting time. There's at some point, I think there was a no contact order between dad and at least one of the kids or something through 63rd District Court. There was an evidentiary hearing set on 12/7/12/22. I think there was a hearing, but no order was ever presented to the court. I don't know what transpired from that. Father now claims CPS is involved, showing abuse and neglect by mom. Says Pine Rest fears for the safety of Xander. I have no proof of any of this. And he said he can't get records. Sir, in order for me to even have a custody hearing, you have to show what's called proper cause or change of circumstance. It's defined in the case of Vadvarka. What is your proper cause or change of circumstance to allegedly have some type of hearing to determine if custody should change?
At the time that I filed that, I did not have the paperwork from CPS because it takes time. But last week I was able to actually get the CPS report, which shows cause of child abuse. I cannot obtain the Pine Rest report because that can only be obtained by the legal guardian, which is her. So without a court order for me to obtain that, I cannot get that one. But did
they substantiate child abuse?
In this report, there are.
I don't care if there's allegations. Did they substantiate? Did they find that there was? They at the very end of the report, it'll say there was or wasn't.
There's not enough to take the kids from her, from CPS point, but they did find child abuse from them medically trying to seek help for that the kids do not need. So there's technical child abuse, but it's not enough for CPS to do anything, which is why I filed a motion to be here.
Well, you got to prove by a preponderance of the evidence there's a proper cause or change of circumstance. I don't know if CPS doesn't find enough to do that, how you think that I'm going to find enough. There's got to be something. I got to have some proof of it.
I'm not able to obtain the Pine Rest report, which shows proof, because that can only be obtained by the legal guardian, which is.
Now, wait a minute. Are you saying CPS didn't talk to Pine Rest?
CPS did talk to Pine Rest, but they only obtained last year's report from Pine Rest. They did not obtain the current, most recent one in November. At the time, they did not obtain that one, which that's the one that obtained or shows.
No, wait. How do you know it shows that if you've never obtained it, and CPS has never obtained it?
I spoke with the social worker there. She's the one that let me know all of this going on.
Ms. Cody? What's your response?
Nothing was substantiated from the CPS cases, and CPS was involved because they were concerned that, like Mr. Hurley said, that we were falsely taking our children to get medical procedures done that were not necessary, and that's not the case, and CPS found that to be not true. They agreed that we were just trying to get services for our children. Our oldest son was recently diagnosed with 8 different mental health disorders, and I have right here with me, I know it doesn't really help, but his psychological evaluation. And I also have the medical disorders that he was diagnosed with. ADHD, persistent depressive disorder, social anxiety disorder, panic disorder, separation anxiety disorder, oppositional defiant disorder, PTSD, and intermittent explosive disorder. And as far as Landon Hurley goes, we haven't been trying to receive other resources for him because we haven't had behavioral concerns with him. But we did with Xander Hurley. And since all of this, he's been on a med change and we haven't had any issues with him.
Okay. When was the med change and stuff like that? I mean, are we talking recently?
It came from Pine Rest.
Okay. So he was in Pine Rest and did some there and they made some changes and now he's all right.
Yep.
And you're saying, sir, that her taking the child to Pine Rest is wrong?
I spoke with the Pine Rest social worker, who's Brittany Hines, and she's the one who said that she feared for his safety. She filed a second CPS report, which I'm waiting to obtain, and she called the sheriff's department to do a wellness check on them.
Okay, and did they do a wellness check?
She also claimed that during the time that Malia and her partner came to pick him up from there, or from Pine Rest, that they were explosive in the lobby and cussing at the Pine Rest people.
That's not true, Your Honor.
This came directly from the social worker.
Okay, so I mean, even if they were angry in the lobby, that doesn't warrant a change of custody. I mean, you got to understand that in order to have a hearing, I have to have at least a preponderance of the evidence, more likely than not, that there is a proper cause or a change of circumstance. And as of right now, I have no preponderance of evidence of any type of child abuse or any change of circumstance and stuff like that. I don't know what the Pine Rest people told you. I'm not saying they didn't, but I mean, you need something of significance in order for me to have a custody hearing. The purpose of this Vidvarka case is that we don't have custody hearings just right and left for every little thing that goes on. There's clearly been some problems in the past with you that are indicated from the divorce file or the DC file in the past. And I think you had no contact with the kids for a while. There's enough to go around here everywhere. But I have to have, I'm not saying there isn't, but you have not proved to a level necessary for me to have a custody hearing at this point. You just haven't met your burden of proof of preponderance of evidence of a change in circumstance or proper cause to even have an evidentiary hearing. So I have to deny your custody motion. All right. If you come up with something better or something that shows preponderance of the evidence, I'll be glad to have a custody hearing. I have them all the time, but I have to hold you to a standard, and you have not come close to that standard at this point. So good luck, everybody. Thank you. I'm denying the motion. If you want to, you can file it if you have other stuff in the future.
Thank you, Your Honor.
We're adjourned.
Fucking piece of shit.
I wouldn't talk like that if I were you, sir. Well, geez, Pete, he had to have psychological exam and everything before he could even have parenting time.